Good afternoon, ladies and gentlemen. Welcome to CHINABRAND Consulting's webinar on China's new Counter-Espionage Law, in short, CEL. It came into force on July 1st this year and has caused a lot of excitement and nervousness among foreign companies operating in China. The waves are running high and the international press is full of articles about this new law. CHINABRAND Consulting is an international consulting firm that focuses on intellectual property protection, know-how protection, as well as cybersecurity and data protection, with reference to China and Asia. IT compliance is also an important topic. The clients are well-known medium-sized and large European brand companies from various industries, but predominantly from the B2B sector. My name is Tamara and I guide you through this webinar today. The picture you can see here shows a police raid on the US consulting firm Capvision, which obtains information on behalf of foreign companies in China. So what were they doing? They weren't researching any military secrets or passing them on abroad. No, Capvision collected competition-relevant business data, like production costs and profit margins from Chinese companies by unfair means. For example, Chinese experts were lured by the promise of high-paying jobs. There were several raids, investigations, confiscations of laptops, equipment, and arrests in China. Also at other Western companies involved in information gathering, including the Japanese pharmaceutical company Astellas. The issue went wide across the Chinese media landscape and was also shown on CCTV. This webinar here was originally held by our Managing Director, Dr. Fuchs, and our Senior Consultant, Ms. Liu Liu. It is reasonable that the international business press is boiling over with this new CEL. With this new law, China is placing Western companies under general suspicion. Everything that is connected to the procurement and transfer of data and information is suspected of espionage. Therefore, the air is getting thinner from companies in China. It is obvious that the actions of the authorities are also a warning shot. The crucial question, however, is whether the situation will calm down or whether the new CEL will have a lasting effect and permanently change businesses in China. And if so, how? Our answer to it is quite clear. Yes, the CEL has a strong effect and permanently changes businesses in China. But what is this new law about? The old Espionage Act of 2014 focused the concept of espionage on state secrets. The classic old intelligence thinking that no longer applies. The law has been broadened to include national security and Chinese interests, and that is important. In the context of national security and Chinese interests of the public and of organizations and individuals, it is all about data carriers, like paper documents, files in all forms, computer hard drives, USB sticks, recordings, and so on, that affect or can affect national security or Chinese interests. That is the central point. The law also prohibits the procurement and transfer of items and materials, such as technical components or samples of powder for coatings for testing purposes that are related to China's security and interests. As a result, all information gathering is now under general suspicion. For example, classic market research, due diligence for M&A or IPOs, all of this is now highly risky. The market researcher who obtains data on Chinese companies for foreign companies could be committing industrial espionage. Cyber attacks also fall under the CEL. For example, if a company in China has not secured its IT systems with the MLPS 2.0 certification required by law, then they are complicit in the espionage activities of a hacker. The logic is clear. The burglar is responsible for a break-in, but you are partly to blame if you left the window open. This means that MLPS certification becomes more important with the new CEL. The law strengthens the requirements of MLPS certification. I will go into more depth on this point a little bit later on. The law greatly expands the power for local authorities implementing the national law. The authorities can investigate and raid, make arrests, close offices, and impose exit bans. The legal punishment system is twofold. For violations, the responsible organization is punished with a fine, blacklisting in the corporate social credit system, or even license revocation. The person responsible within the company for obtaining and transferring data and information is personally liable and will be punished with a fine, imprisonment, and blacklisting in the social credit system. The law does not specify penalties. The local manager responsible for China at the headquarters can also be held liable. By emphasizing Chinese interests, the CEL remains vague. This is the central point of criticism of the companies against this law. It leads quite to considerable legal uncertainty. But what all falls under Chinese interests? There are no exact clear definitions. Local authorities are responsible for interpreting the law. This opens the door to arbitrariness and overzealousness on the part of officials. Let's have a closer look at the law itself. The very first paragraph of the first chapter emphasizes Chinese interests, the interests of Chinese individuals, organizations, and the public, in addition to national security. This emphasis on interests is repeated again and again in the text. In the end, that is what it's all about. It is not about national security aspects. Those have already been covered, for example, by the new national security law. In recent years, Chinese security laws have become much stricter. Today, we speak of securitization of everything. China spans a tightly meshed security net over the entire economy. There are no more loopholes. The National Security Law of 2015, on the other hand, was quite inoffensive. It has not greatly affected any of our customers. The situation now is quite different in network security with the cybersecurity law. This law has affected many companies, if not most of the companies established in China. The cybersecurity law is now gaining reach and influence through the mandatory MLPS 2.0 certification. We should not overestimate the 2020 encryption law shown here in blue. Encryption is not the big issue. It happens often but has no great legal relevance. Encryption is a side issue. By the way, there are already interests in this law. Section 12 of the encryption law prohibits the encrypted transfer of data that concern national security and national interests. The export control law, which concerns the security of the export of dual-use goods and services, has not been particularly relevant for most companies either. Only a few were affected. However, we are now registering more inquiries because of the export control law also covers data and know-how related to dual-use products or services. The new CEL now sheds light on the data and know-how holdings of such products and services. With the data security law and the personal information protection law, the reach, scope, and impact on businesses in China increases even more. The risk for companies increases significantly. These laws have a big impact in most businesses. We hardly have a client who is not affected by this. With the new CEL shown in purple here on the right in the chart, the situation is equally exploding because it is about protecting Chinese interests. Pretty much all companies are heavily affected in very many areas and activities. The law is comprehensive, spinning a tightly woven safety net that leaves no loopholes for companies and greatly increases their risk across the board. And actually, this law is not really a counter-espionage law, it is more an interest protection law. What categories of data are affected? All data that China has no interest in leaking. it is essentially about competition-relevant economic and technical data of Chinese companies, industries, and markets. For example, shareholder structures, ownership structures, balance sheets, affiliations, company networks, contracts, reputation, and so on. Of course, the sensitive complex of intellectual property plays also a major role, as does technical know-how, which legally falls under the category of trade secrets. This includes, for example, cost data, formulas, process data, or business plans, all data relevant to competition. China does not want this data to leave the country. A simple example from practice. A foreign pharmaceutical company operating in China can now no longer easily send its extensive sensitive test data of Chinese citizens for a planned new drug to their headquarters because of the new CEL. The company cannot get permission to transfer the data or does not dare to apply for it. What this means is the market launch of this new Western drug in China is delayed. This gives Chinese pharmaceutical companies a competitive advantage because they can bring their drugs to market faster. So this is basically the context of this law and the other data protection laws. We always have to consider laws in their context in order to understand their intention. There's no purpose of decoupling behind the CEL. It has a decoupling effect, but decoupling is not the real aim of the Chinese government. China does not want to further decouple itself from the West with this law. The goal is to implement the strategy of dual circulation and to ensure and support the politically intended dynamic upward spiral of the country's development. In the future, the aim is to strengthen the domestic market and upgrade Chinese industry. Innovation will be promoted and competitive advantages strengthened. Autonomy will be increased. Chinese companies will be supported and foreigners will be selected. China wants to separate the wheat from the chaff. Foreign companies that only want to make money and compete with Chinese companies, but do not contribute to the development of the country or even harm the development, are no longer wanted. Stopping the outflow of data, information, and knowledge is then only logical. This is the political and economic context of the new laws working together. The influx of data from abroad is still desired. China needs Western data, information, and know-how for its further development, especially in the areas of cutting-edge technologies that are relevant for the future. But these are only available to a limited extent due to the increasing geopolitical blockades and containment strategies. This results in a higher risk for Western companies of losing competitively relevant know-how. They have to disclose data, information, and knowledge during investigations and controls under the new CEL. And there may be an undesirable transfer of technology. This is the other side of the coin. Chinese counterintelligence corresponds to the undesired outflow of data and information. Local authorities have a free hand. There are no implementation guidelines for the CEL yet. Officials may also develop proactive obedience, interpret the new national law, and then crack down. Foreign companies operating in China's key strategic areas have a particularly high risk. The corresponding technology fields are published in the various strategic plans and are being built up sustainably by the central government. These include the 10 areas of the Made in China 2025 plan, as well as the newly defined strategic investment focus areas and the areas of new infrastructure and technologies with the multiplier effect. You can see these areas and technologies on this slide. With the CEL, foreign companies that are directly active here or have a connection to it will have a higher risk in the future that know-how will flow out or that they will violate the law in the course of their business activities. Let's take a closer look at some possible risk scenarios. One of them is, of course, the unknowing collection of data. You collect and export data and information in the course of your business, and you do not realize that you are violating the CEL. To prevent this, you should conduct a risk analysis before engaging in data activity. Scenario number 2, you recruit an expert who has access to key data or sensitive information at a Chinese company and has a specialized know-how. This recruitment may be considered espionage or complicity in espionage, especially if it concerns the strategic technology areas described. After all, they could try to skim off Chinese know-how and transfer it abroad, and that is not in China's interests. Scenario number 3 and 4 displayed here are data exchange that always happens in cooperation or in your Chinese ecosystem. You don't know how reliable or how honest your partners are, and it could quickly be suspected of involvement in espionage if their activities do not comply with the law. The corporate social credit system also provides for a kind of collective liability. Scenario number 5. It becomes very difficult with supply chains, for example with the German Supply Chain Duty of Care Act, or the requirements of the European Union. Here, two legal systems collide. You have to carefully check your Chinese suppliers for compliance with working conditions and human rights. Chinese law explicitly prohibits this. Scenario number 6. We had already touched on market research. Information that you obtain and export can be critical information that is now covered by the CEL. Aggressive poaching as scenario number 7. If you recruit professionals too aggressively, they may be suspected of wanting to obtain sensitive knowledge. They come to the attention of the authorities, maybe. And the last scenario provided here, scenario number 8. Many companies have Chinese persons checked by detectives via background checks. There are service providers, for example, former police officers, who specialize in this. This is also no longer possible. A German investigator reports that more and more information and informants are withdrawing and no longer offer services. The classic investigative background check is no longer legally possible in China. Scenario number 9, transferring the data transfer risk to cloud service providers. Unfortunately, this strategy falls short because cloud service providers usually lack compliance. This is shown by precise analysis of their data activities. Cloud compliance is currently a very important topic in China as well. If you hire a cloud service provider that does not operate in compliance with the law, you're jointly responsible. Scenario number 10, the transfer of product-specific data of Chinese customers from the branch office to manufacturing in the foreign headquarters. Number 11, product specifications. The Chinese branch of a machine manufacturer sends the product specification of the Chinese customers to the foreign headquarters for the production of a specific machine. With the CEL, this can become very difficult in the future if important data from Chinese customers are involved. This is especially true if the customers are from the strategic technology fields. In the final consequence, the Chinese state could demand that the production of the special machine should be relocated from abroad to China so that the sensitive data remains in the country. This is where the 28th of the 36 Chinese stratagems show up. Lure someone to the roof and then pull the ladder away. Scenario number 12. Quite a few European companies earn good money with the remote maintenance of machines in China. For example, with the HoloLens system on Microsoft Mesh. It is not uncommon for this to involve machines and equipment running in factories and public buildings in China. In this business model, data that can be considered important in the sense of the law is constantly being transferred abroad. Scenario number 13. There are European manufacturers who use a digital twin to monitor their machines and equipment in China, which run in public facilities, government buildings, or hospitals. The risk of this business model is obvious. Personal data is exported out of China. Scenario number 14. Personal data is exported out of China via social media. It can be assembled into profiles of individuals and groups abroad, which is not in the interest of the Chinese government. Even within China, the government has severely restricted the creation and use of user profiles. Scenario number 15. We have already mentioned export control. Because the data and know-how contained in goods and services with the possibility of dual use, the export control law gains importance with the CEL. This is especially true for the concept of important from ASEAN countries and re-exporting when products are refined in China and enriched with critical data through refinement. And the last scenario, with the progressive politicization of the Chinese economy, the so-called party cells in companies are gaining weight. Party members in the executive floors of foreign companies in China have insight into the procurement and cross-border transfer of data and information. All these risks naturally increase the risk of an internationally active company and can increase its global risk exposure to such an extent that they have to be listed in the risk report. In the other case, the company could come into conflict with the relevant national laws in its home country. So, what courses of action do foreign companies have regarding the procurement and cross-border data transfer of data in China after the CEL comes into force? There are various strategies and measures with which foreign companies in China can and should react to the new law. The first option is to use open source intelligence, also known as OSINT. This approach is gaining importance in the information economy because there are many ways to use publicly available information sources in the depth of the internet that are completely legal. We work with Chinese tools in this approach. For example, this shows a tool for researching information on trademark awareness in China with a timestamp for notarization, which is, for example, needed for trademark infringement lawsuits. These tools are not free. Their use requires quite a budget. On the top left, you can see the geolocalization as a source of information. Here's an example. Competitive athletes like to send their training data via their digital wristwatch in real time to the internet, for example, to be able to compare themselves with other athletes. In one case, it was found that several athletes repeatedly run around a larger rectangular area as a training spot. More in-depth research then revealed that it was the outer perimeter of a previously unknown military barracks. The soldiers regularly ran around the fence of the facility for training, and afterwards they sent their training data to the internet via the mobile phone network. Another strategy for legally obtaining information is to use reputably service providers. This strategy is used by CHINABRAND Consulting. Before an order is placed, the company assesses the risk and only agrees if the data collection and information procurement does not collide with Chinese laws. Compliance is an essential requirement for this. The consultancy science, a code of conduct for suppliers, identifies possible experts for interviews and then obtains written consent from the interviewees, often industry experts and professors from specific fields. This process is relatively time-consuming and costly but usually produces excellent results, which are needed for demanding projects such as M&A, due diligence, or relocations. This procedure is also used for sensitive research on supply chains. The results are usually very, very good. Information gathering in the area of anti-counterfeiting. These are fighting Chinese trademark and product piracy at the source. Is unproblematic, even with the entry into force of the new CEL. In this area, there's close cooperation with the authorities anyway, for example, with the local police or the Administration for Industry and Commerce. And finally, the fight against counterfeiting is in China's interests, and the authorities themselves are massively involved here. Let us take a closer look at further options for action from the perspective of classical risk management, which distinguishes the identification, assessment, and handling or management of risks. We can avoid risks resulting from the CEL by either completely refraining from collecting and transferring data across borders or by reducing them. So do we need this or that data at all, or do we need to transfer it abroad? The Chinese authorities ask for a valid justification when companies want to have a data transfer authorized. However, if they want to identify avoidable data collection and transfer of data, companies operating in China need to conduct robust data mapping and data flow analysis. We reduce risks in the area of data collection and transmission by making the system strictly compliant with the law. In the past, there were always loopholes in China, but these are now closed with the extremely tight safety net of laws. It is no longer possible to circumvent the security laws. The risk situation is now so high, not least due to the ongoing geopolitical forces, that attempts to circumvent the laws are strongly discouraged. Compliance is now indispensable in China. This also means that we have to adapt, expand, and professionalize the compliance management of the Chinese companies in order to reduce risks. We pass on risks to reputable service providers who now obtain data in a legally impeccable manner, and to cloud providers who, however, must comply with all legal requirements. The internationally active cloud providers were also surprised by the CEL and have not yet been able to sufficiently adapt their systems. The compensation of risks is quite challenging. Risk compensation is possible when a risk is counterbalanced by an opposing risks. Blocking certain corporate data is in China's security interests, but so is maintaining economic growth and innovation. The latter can be cited as a justification when applying to the authorities for cross-border data traffic. After avoiding, reducing, passing on, and compensating risks, there remains a risk that companies in China have to bear. Even with the remaining risk, we can discuss options, but these must be examined for their feasibility and legality. Most companies do not know in detail what data they collect, store, process, provide, and transfer across borders. But because this knowledge is a precondition for compliance with China CEL, professional data mapping is indispensable. When it comes to data mapping, it matters what types of Chinese companies you work with. If your customers in China are private companies with general data, there's no significant risk of transferring data to headquarters in terms of the CEL. However, if the clients are large state-owned enterprises or critical information infrastructure operators, in short CIIOs, and hold important information, the risk of data transfer increases significantly. CIIOs include not only companies from the energy supply, transport, telecommunications, water supply, finance, public services, e-commerce, food and pharmaceutical and chemical industries, but also science and technology, including their subsidiaries. Here we again come across the risky strategic technology fields that play a central role in the country's development. China's data protection laws distinguish between general data, important data, and core data. The classification of data is based on the degree of impact on national security, public interests, or the legitimate rights and interests of individuals or organizations once the data has been sabotaged, destroyed, leaked, or illegally accessed or used. So the first category, general data, are any record of information in electronic form, usually data elements and records. A data element is a column field of a database table. A record is a collection of several data elements, like a database table. There's distinction of 4 classes. Important data are generally not personal data and internal management information of companies, but personal data of a certain scale or derived data resulted from the processing of a large amount of personal data. The last category, core data, include national data affecting national security, the lifeblood of the national economy, the livelihood of important people, important public interests, and so on. Industrial data is data generated and used throughout the life cycle of products and services in the industrial sector, including data generated and used by industrial companies in research and development, manufacturing, management, operation, and maintenance, as well as data generated and used by industrial internet platform companies when accessing devices, operating the platform, and applying industrial apps. Data generated and used by industrial enterprises in accessing devices, operating the platform, and applying industrial apps, and so on. CHINABRAND Consulting prepares data categorization within the framework of projects. The decision on classification lies with the authorities. Metadata and encrypted data play a special role. Metadata is the information about data such as storage, location, content description, record number, and so on. This metadata is generally not as sensitive, but can be highly risky. There's a catchy example of the risk with metadata. So imagine you are watching your colleague, for example, Janet. You're watching your colleague, Janet, excitedly talking on the phone in the office. And you would like to know the content of this phone call, but contents of phone calls are confidential data. But the metadata of this phone call are easily accessible. The caller, the call time, and the person called. These metadata characterize the data of the telephone call. So you know the name of the caller, Janet, it's your colleague. You know her full name, and you know the time of the telephone call because you saw her calling. So now you want to find out who called. You go, or who she was calling. So you go to Janet's desk during her lunch break. You press the redial button on the phone, and then you can talk to the person. And the person she called was an abortion clinic. Further research into the data is unnecessary. So in the same situation as an official who, during a check, sees the branch manager nervously phoning and after pressing the redial button, it is connected to the development manager of a Chinese state-owned enterprise who has important technical data and information that is of the greatest interest to the foreign branch being checked. Encryption is another critical issue. Many companies feel safe when transferring data across borders because they encrypt the data, end-to-end or in transit. Both are possible and legal in China. However, most companies overlook when encrypting and transferring data that requires authorization, which falls under the CEL. According to Section 12 of China CEL, it is forbidden to transmit data concerning national security and Chinese interests in encrypted form. Data mapping must be used to map the data flow. What data is collected, stored, processed, transmitted, made available, or shared? Why, how, and where? These are all very important questions to consider. The data flow is shown in detailed data flow diagrams, which the authorities require for the processing of applications for cross-border data traffic through standard contractual clauses. Important questions from the data authorities concern the type and amount of data, the reason for the data transfer, the consent of the data owners for collection and transfer, the transfer method, and the foreign data recipient. The new CEL also forces foreign companies established in China to review their concepts of cross-border data transfer. Here you can see three typical basic scenarios. In type 1, the Chinese subsidiary transfers data directly to the headquarters, customers, or authorities abroad through email, FTP, or SharePoint. From a Chinese perspective, this is an export of data. Type 2 is more complex. If the headquarters operates IT systems abroad, for example, a CRM system or an ERP system, and the database and server are also located in Europe, then the Chinese subsidiary uploads its data to the system. This type of data management represents a deployment with cross-border data traffic. In example number 3, there are different scenarios. The Chinese subsidiary runs IT systems in China. The servers and databases are located in China. The corporate headquarters accesses the data stored locally in China. If a non-Chinese employee of the head office is traveling within China and has mobile access to the domestic Chinese IT systems there, the access could be considered cross-border data traffic. However, this scenario is controversial in the context of the data security law and the personal information protection law. In all cases, the CEL concerns the storage, processing, provision, and transmission of data. After data mapping, companies will know whether their Chinese branches or subsidiaries reach the critical levels in the transfer of personal data and need to undergo a strict security assessment by the Cyber Administration of China, in short, CAC. Many companies have already made the security assessment requests, but their data transfer request has mostly been rejected. In the future, if the company does not meet the triggering thresholds of the security assessment, it can apply for security certification or sign standard contractual clauses with the overseas data recipient. For security certification, the rules of the game are not yet clear. A certified company can export its consistent data for 3 years without further control by the authorities, but it is still unclear to which testing bodies can apply. The provisions for the standard contractual clauses for the export of personal data have been enforced since the 1st of June this year. The requirements of the SCC procedure are not easy to fulfill. A requirement is the performance of a personal information security impact assessment, the report of which must be submitted to the local authority. It is important to justify why the data must be transferred. In addition, the applicant must describe in detail the technical details of the transfer. This includes transmission capacities, IP address, bandwidths, and data regarding the routes and connections of the cross-border data flow from China to the recipient. In the multi-level protection scheme 2.0, the major role of Chinese interests becomes visible. National security does not yet play a role in the risk levels of level 1 and level 2, but public interests and the legitimate interests of citizens and organizations do. This means that the interests are risk relevant from the outset and are classified as questionable or very questionable at level 3, which many companies operating in China reach. Here, national security still ranks below the status of general. Most companies operating in China have a more or less sophisticated compliance system. This should now be adapted to the CEL. We recommend setting up a compliance action plan. The content includes updating internal compliance policies, setting up a 24/7 reporting system for unclear or suspicious data transactions with escalation levels, and introducing espionage and liability clauses in contracts. Due diligence processes for applicants, suppliers, and business partners must be reviewed and adapted to the new law. And employees, suppliers, and partners must be trained. It is important to prioritize corrective measures for reasons of time and costs. The legal requirements in China have now become so extensive that the introduction of an IT-supported compliance management system pays off. Risk compensation is a challenging and difficult strategy. Companies need to find a risk that counters the Chinese risk of data loss. The Chinese state has a risk of unwanted data export abroad. The affected company points to the risk to the Chinese economy and society that if data flows are disrupted or interrupted, Chinese customers cannot be sufficiently served, Chinese suppliers cannot be effectively used, and Chinese employees cannot be paid or employed. In short, blocking the data and information activities of the foreign company ultimately harms the common good and the development of the country. New opportunities may arise when using IT systems in different jurisdictions. We should look at using a third country for cross-border data traffic. Singapore, for example, is a very popular data hub, very China connected. Data transfer from China to Singapore is not as tightly controlled as data transfer to the US and Europe. Can we use this hub in data transfer? The picture shows an example from virtual reality with a virtual twin of a machine that is operated in China and monitored and controlled by the German headquarters. The control data for avatars, communication data, and machine data are transferred. So, coming to the last slide, can we use data mesh for cross-border data traffic and information management? With data mesh, the data flows back and forth as a permanent flow in real time between different domains. For example, the branches and the head office. Technical latency does not play a major role because we can work with minimal delays in international data traffic. The network can be controlled via the head office and the individual branches can be connected to each other. This future topic is currently high on the agenda of CHINABRAND Consulting, and we are staying on the ball together with specialized IT service providers. If these topics are of interest to you, please feel free to contact us. We are happy to answer any questions you have. On behalf of CHINABRAND Consulting, I thank you for your time and attention, and I wish you a good time.